let's talk about joint estate planning documents. And you might not know what I mean by that. So what I mean by that is a type of estate planning that is done with couples. So husband and wife, for example. And they could have a will that is what's called a joint will. They have their own separate wills, of course, but these wills not only mirror each other, but they contain some sort of statement or provision that these wills cannot be changed ever, even after the death of the first spouse. This is a horrible idea, terrible idea, because estate planning is all about planning for what the circumstances in your life are. And even if they are something at one point in your life, well, life goes on and the circumstances will change and they will be different. But if you have a joint estate plan, a joint will, what happens then after your spouse has died and you want to change the provisions for very good reasons? You can't. You are tied. You are to that will that you have. You are stuck in time to the point where you and your spouse did this joint will, which could be years ago, many, many years ago, and it's a completely inappropriate will now. So joint wills, very bad ideas. It's not a bad idea, though, to make sure that if you want to basically guarantee that your joint kids will get assets, that they will. How do you do that? You do that through trusts that are in the will. Trusts that say on the death of the first spouse, everything goes to the surviving spouse in a trust, and thereafter, when the surviving spouse dies, everything goes down to the kids. So this accomplishes the first spouse's wish that the kids will be provided for no matter what else happens in life, and that the surviving spouse can't change the will, at least not with regard to the first spouse's assets that pass to the trust. So that's how it should be done. It should not be a joint will. Joint wills are not the only problem. I have seen joint durable powers of attorney. So the joint durable powers of attorney say the same thing, that my spouse can't revoke the power of attorney, can't change the power of attorney, everything is stuck where it was. So what happens? The law changes. In 2017 in Washington, our law changed from one statute to another. But the spouses, especially when one has incapacity, and this is what I'm talking about. So let me give you an example. Husband and wife did a power of attorney in 2010. They're both of sound mind, and it's a joint power of attorney, and it says that they have only these limited authorities to do things. And then the husband loses capacity, and he no longer can take any action to change his power of attorney because he has incapacity, so they can't mutually agree to do a new power of attorney. And this joint power of attorney does not give authority to the other spouse to change property status agreements. So they might have what we call in Washington a three-pronged community property agreement. I know I'm getting into the details, but I'm hoping this will help explain. And they have a community property agreement, and it's a three-pronged one. What that means is on the death of the first spouse, everything goes to the surviving spouse outright, can't be protected, isn't in trust. And the powers of attorney, the joint one, doesn't allow them to revoke that community property agreement, do a separate property agreement. It ties their hands into their estate plan that was appropriate in 2010. Well, husband now has dementia. Husband is now going to go into a nursing home. Husband could be eligible for Medicaid with proper planning. None of the planning that we could do to protect this couple's assets are possible because of this joint power of attorney without adequate provisions in it and tying the hands of this couple. By that I mean the lawyer can't help them. We can't revoke this community property agreement, which is what we should do. We can't put all the assets in the name of the well spouse, which is what we should do. And on the death then of this couple, rather than their kids getting their assets, the assets are going to the state. Terrible result. So all of that, and why I'm so passionate about this, is that there's so much good planning that could be done to protect assets for the couple and for their family. None of it can be done in certain cases, the case I just described, because it was a joint estate plan where they agreed that they were always going to be tied to an estate plan from years ago, and it can't be changed. Joint estate planning is a terrible idea when it restricts the ability to change it in the future.